with everyone. We're still having trouble connecting with the defendant. There we go. Looks like there's a connection there. And I've got an unidentified telephone device in the waiting room. Are either of you expecting anyone else who's not already present?
I don't think so.
Mr. Coleman attending, Eric?
I don't believe so.
All right, I'm just going to see who that is so I can put a name on it, and then we'll move forward with your case. Okay, I just let somebody in. I can only see your silhouette. What is your name, please?
Dion Wilson. Can you hear me?
I can. I was just looking for your name on my list of participants, and I didn't see your name anywhere. Say your name one more time.
Dion Wilson, represented by Alfred Brandt. Supposed to be for 10:30.
I think you might be in the wrong courtroom, sir.
No, it's a civil case. Judge LaFlamme.
What's the name of the case?
It's a civil case about money.
Gotcha. What's the name of the case?
What do you mean by that?
Who's the plaintiff and who's the defendant?
I'm the defendant. JNet is the plaintiff. I mean, JNet trying to keep my money, so I guess, I don't know how that works. That was
removed from my docket, sir. I signed an order granting an adjournment. So talk to Mr. Brandt. He can bring you up to speed on that.
Okay. All right.
Okay. Sorry about that, folks. Shannon, you can put us on the record now.
Okay.
This is a matter of Pluff versus Bateman and Coleman. We've got Mr. Kaiser representing the plaintiffs. We have Mr. White representing defendants. We've got a Mr. Thomas Bateman, one of the defendants, present. So, Mr. Kaiser, go ahead with your motion.
For the record, Your Honor, Mr. and Mrs. Pluff are present with me in my office this morning as well. So, Your Honor, as you're aware, I filed a motion for a preliminary injunction. To give a little bit of background to the situation, my client's address and Mr. Bateman's residence abut one another. And essentially, Mr. Bateman's residence is from the back of my client's back door to his front door is approximately 200 feet. What's been happening over the course of the last year while this circumstances have been pending is Mr. Bateman has installed a livestock facility on his property, which we addressed in the motion and actually took that up with the Michigan Department of Agriculture. And Mr. Bateman abated what was an issue at a certain point in time by removing the livestock facility from the property line and moving it back. What's continued to take place since the case has been filed is that Mr. Bateman continues to engage in activity between the hours of midnight and 6 a.m., essentially operating his tractor with a backhoe, grading his driveway. And we believe that the only reason that that's been taking place, especially during the time frame in which it's been taking place, is essentially to harass my clients. It happened on Thanksgiving, it happened during the holidays, it continues to happen. We were hoping that upon this case progressing, that some of that activity would have ceased. It brings into play the Michigan Right to Farm Act, which I know that Mr. White, based on his answer, is essentially asserting that Mr. Bateman is allowed to engage in these types of activities because he is protected by the Michigan Right to Farm Act. Our response to that, Your Honor, is that first, the activity that he's engaging in is not a farming activity. What he's doing is grading his driveway and grading his property and running a tractor in all hours of the night. I'm not testifying in this circumstance, but I think it's common sense. I live in a rural area, Your Honor, surrounded by farms. I'm not awoken every night by a farm operation, by tractors running by my house within 100 feet of my house, grading their driveway. That's not a farming activity, and because it's not a farming activity, it's not protected by the Michigan Right to Farm Act. Second, even if it is deemed to be a farming activity, Your Honor, there are generally accepted agricultural management practices that come into play. The Michigan Department of Agriculture puts out these generally accepted practices, and while doing that, they also do site determinations to determine if a site meets the qualifications for different activities. And in this particular situation, the generally accepted agricultural practices, there's a manual that comes out that says if a site in particular is amenable to farming activity. And in this particular case, we would argue that this is what's called a Category 4 site under the Michigan Department of Agriculture. A Category 4 site is a site that's not amenable to farming activities. And because it's not amenable to farming activities and labeled as a Category 4 site, it reverts to whatever the local zoning ordinance. That is what has control over the situation. The reason that it is a Category 4 site is because the livestock facility is within 250 feet of a non-farming residence, meaning my client's residence. Like I said, there's about 100 feet from my client's back door to the property line. This driveway grading and activity that's taking place is happening right along the property line, maybe 20 feet off the property line. And it's happening essentially every night between the hours of midnight and 6 a.m. He's not feeding his livestock. He's not planting crops. He's not running some sort of farm equipment in furtherance of his farm. He's grading his driveway and creating such noise and disturbance that my clients can't sleep, Your Honor. He's not protected by the Michigan Right to Farm Act for one reason. As I've already stated, he's not engaging in farming activity. And two, even if he was engaging in farming activity, the local ordinance is what controls in this situation because of the size of his property, the distance of the facility from my client's residence. It's deemed to be a primary residential area because based on the definitions found in the generally accepted agricultural practices, an area that's primarily residential is any site that has non-farm residents within 250 feet of the facility. And this certainly meets that requirement.
Well, let me stop you for a minute. What township ordinance, and I see you've attached some to your complaint. What township ordinance is addresses grading of his driveway?
What we're talking about is Tompkins Township Zoning Ordinance 4.04-1, which is the control of heat, glare, fumes, dust, noise, and vibrations. And it states that every use, and this applies to all zoning districts, Your Honor, every use shall be so operated that it's not obnoxious or dangerous by reason of heat, glare, fumes, dust, noise, and vibration beyond any boundary line of the lot or parcel of land on which it is located. So in this situation, Your Honor,
basically that's a codification of general nuisance law.
Exactly. And what we're saying is, Your Honor, is that grading his driveway is not necessarily an obnoxious noise or vibration when it's done in a normal course of when it's needed. What we're saying is that it does. What makes it obnoxious is that it's happening at 2 a.m. or 3 a.m. when they have their grandson over spending the night, and he's awoken in the middle of the night to the sound of a backhoe running 80 feet from their residence. I mean, it's just to the point where I would hope that common sense would take over and say that this type of activity is only intended to harass my client, Your Honor. There's absolutely no reason that anybody needs to be running a tractor at 2 a.m., let alone grading their driveway 80 feet off their neighbor's back porch. It's intended for the sole purpose because this has been a situation where there's animosity between neighbors. Mr. Bateman is obtained a personal protection order against Mr. Pluff for issues related to security cameras and things of that nature. There's animosity that's built up. I would suggest that Mr. Bateman is probably not happy that he had to move his livestock facility off the property line. And we view this as his retribution against my clients, just essentially trying to get them to move. All they're requesting, Your Honor, is an order that says that he can't operate his tractor in the middle of the night. I don't see how that type of activity can be protected by the Right to Farm Act. And truthfully, I researched noise and those types of issues under the Right to Farm Act. They're not addressed in any of the generally accepted agricultural practices that I could find. But again, we don't believe that this is a farming activity. And even if it is, because of the type of site that he is operating, it's still the local zoning ordinance that controls. He's not covered in any way from abiding by the local zoning ordinances. And again, we believe that the noise and vibration of him grading his driveway at 2 a.m. is obnoxious as defined by the ordinance and should be abated.
Thank you. Mr. White?
First of all, the facts that Mr. Kaiser talks about are a fabrication. My client absolutely denies the allegations. He's out there every night after midnight grading his driveway. It's simply a made-up story. You'd also notice that this motion doesn't really comply with 3.310. There's no affidavits. There's no anything. In addition, did you notice that the plaintiff never cited a single generally accepted agricultural management principle that they claim to be violating, and in fact fails to inform the court of MCL 286.4746. This went into effect June 1st, 2000, and completely preempts all township and local ordinances that are in conflict with the Right to Farm Act. Of course, the ordinance they're talking about was passed in 1990. It's all been preempted, and it's very important, that statute. The fact is that this property is zoned ag. My clients are operating a farm, and if my client wants to feed his cows at 2 o'clock in the morning, he is absolutely in his right. Perhaps the neighbors, the plaintiffs, would like my clients to plant some corn. I don't know where you live, Your Honor. I live in the country. I hear corn dryers at certain times of the year that sound like jet engines that are going all hours of the night. And you know what I can do about it? Nothing. That's protected by the Right to Farm Act. That's what all this is. I'm skeptical about what's going on here. You notice this case was filed in August. And as I mentioned in my answer, the plaintiffs have done nothing. They've sat on this case since August. And right before this is coming to a conclusion, we all of a sudden get a motion for a preliminary injunction. They've offered nothing other than some anecdotal evidence that every night, apparently after midnight, my client's out there with his tractor. Of course, in their petition or their motion, they talk about heavy equipment. You can see my client has a light. It's actually a utility tractor is all it is. It's a John Deere utility tractor. That's his entire heavy equipment. How much noise that could make at any time doesn't make any sense. The fact is, this is an operating farm, and this is what the Right to Farm Act exactly does. I can tell you that Tompkins Township is not getting involved in this because they're well aware of the Right to Farm Act, and their ordinances have been preempted by the statute that I've cited. It's important to note who got the PPO here. My client had to get a PPO against the plaintiffs in this matter, and they tried to set it aside, and Judge McBain didn't buy any of it. You can see who the aggravating person is as to who's got the PPO here. This is set for trial, Your Honor. I think they've not met their burden. They've not followed the procedures to get a preliminary injunction. We'd ask that you deny it.
May I respond, Your Honor?
Well, before you do, I certainly would not grant a preliminary injunction when the facts are disputed without taking testimony and deciding indeed what is in fact happening. My inclination would be, if indeed Mr. Bateman is doing what he's being accused of, which is purposely running equipment, whatever it is, near the plaintiff's residence in the wee hours of the morning, not for any farming activity, but simply and solely to aggravate his neighbor, right to Farm Act notwithstanding, I'd probably be inclined to issue an injunction that says, don't do that. But I don't know what the facts are. The facts are disputed. I don't think there's anything in the Right to Farm Act that would prohibit me, independent of what a township ordinance is doing, from keeping a farmer from spitefully treating his neighbor as opposed to conducting a legitimate farming exercise. And I wouldn't hesitate to do that if I found that that's what was going on. But I couldn't issue an injunction today without taking testimony and finding out what is he doing.
My clients would be happy to testify to those issues, Your Honor, but here's another point that I would make is that if he's saying he's not doing these activities, then why would he be opposed to an order that restrains him from engaging in that type of harassing type of activity? And in response to Mr. White's criticism of our filing here, Your Honor, the complaint that was filed in this was a signed sworn statement from my clients. It was notarized. It was submitted as an affidavit to the court. And he's correct that the Michigan Right to Farm Act preempts local zoning ordinances when the farmer is complying with all the applicable generally accepted agricultural practices. Mr. Bateman has the burden of showing that he's complied with those types of practices. And the way that you show that you're complying with those types of practices, Your Honor, is that you ask Michigan Department of Corrections to come down and certify you as a particular type of farming facility and that you're complying with those types of practices. I would ask the court to err on the side of caution. As you said, that there is a trial that's pending. In the meantime, my clients shouldn't have to withstand an activity that Mr. Bateman says he's not even engaging in, running his tractor in the middle of the night. We're just asking for an order until the trial so that you can hear that testimony that prevents Mr. Bateman from grading his driveway between 6 a.m. or between 12 midnight and 6 a.m. We don't think we're asking for a lot there, Your Honor. We'd like a longer, stretch of time, but my clients would like to sleep. I mean, that's really what it comes down to. It's been going on for quite some time. They would like to have it resolved so that they can at least rest during their night. And again, if Mr. Bateman is saying that he's not engaging in this, I don't understand why there would be any problem with granting an order that says, don't do it. I mean, it's just, if he was out feeding his pigs or cutting corn or doing something along those lines, Your Honor, my clients wouldn't be filing this. The activity that we're talking about is running a tractor up and down his driveway all hours of the night. It'd be the same thing if he was playing rock music, at the back of his property. It's an activity that's entirely designed to harass my clients. And so if he's not engaging in it, then why not? If he's stating he's not engaging in it, why are they so opposed to an order that prevents him from doing it?
Well, it's not the same as rock music, Your Honor.
It doesn't, Mr. Kaiser. I understand the arguments you're making. I'll repeat. I don't believe there's anything in the Right to Farm Act that would protect Mr. Bateman if what he's doing is not farming, but irritating his neighbor. He's denying that he's doing that. I guess the only way I can decide, I don't issue injunctions to keep people from doing something that they're not doing, unless they agree to that, and he obviously doesn't agree to that. So I have to, is it in fact happening? Is there any justification for it if it is happening? If there is none, I would tell you, I wouldn't hesitate to issue an injunction. I don't think there's anything in the Right to Farm Act that would protect activity that's for the sole purpose of harassing your neighbor. I do see that there was a jury demand made by the defendants. Is that correct, Mr. White?
Yes, Your Honor.
The soonest that I could hold a jury trial is going to be, I'll know better in May than I do today. But a jury would simply decide damage issues. The relief of an injunction isn't something that's within the realm of the jury. That's something that's for the court. But I would not enter an injunction without taking proofs as to whether or not something's actually happening. And I get Mr. Kaiser, that your clients say it is happening. But Mr. Bateman says it isn't. I'm not going to enter an injunction against something that isn't happening.
Is there any way that we can conduct an evidentiary hearing prior to the trial just on the motion, Your Honor?
I was
My
going
clients would like to address this sooner rather than later. And given that really it's the only remaining issue, it's something that could resolve the case prior to the need for a trial. If an injunction was issued, my clients wouldn't have much reason to pursue any further relief. So,
if I may suggest, Your Honor, we have a trial date already set of April 28th that should still be on your calendar, that was given out as a case scheduling order for a jury trial. Perhaps we could take some of that time that's already scheduled. I don't know what your schedule looks like, but perhaps we could use that scheduled date to take some testimony on the injunction issue.
Let me take a quick look at that date. Take me a moment to pull it up. I got to log in first. Give me the date again, Mr. White.
Set for April 28th. It's a Wednesday morning, I think.
I could certainly reserve that date for you to take some testimony and at least rule on the issue of injunctive relief.
That'd be great.
If that's the only remaining issue, there wouldn't be anything left for a jury to decide, would there?
No, Your Honor.
I don't believe so.
All right, let's just plan on that. Mr. Bateman, I'm not judging anything today, okay? I realize that everybody's entitled to their day in court. I would strongly advise you, if you want your case to be viewed favorably by me, that between now and that hearing date, that you not do things to irritate your neighbor in terms of running equipment in the wee hours.
Yeah.
Don't, Tom.
I don't, like I said, Mr. Bateman, I haven't heard proof, so I don't know who's speaking the truth here. I'm merely telling you, if that's how the truth shakes out, I would not view that activity favorably, so take that for what it's worth. Okay, thank you. We'll see you all back here on the 28th.
Thank you, Your Honor.
Talk to you next week, Tom. Thank you all.